Hola, Richard. How are you?
Morning, Valma. Morning, Glennis. Good morning, everybody. Welcome to the meeting, members, and welcome to everybody.
Good morning, Chair.
Sia, I know we have enough members to start the meeting. The department, is it here? And the Deputy Minister? Honorable Olomisa, are you here? Not responding. Thank you. Good morning, honorable members again. Let's start our meeting. It's exactly 9:30, our starting time. Welcome everybody for this subcommittee meeting on correctional services to deal with two issues. The healthcare services in these correctional centers, as well as getting a progress update on the suspension of the KZN Regional Commissioner. So I'm going to invite the Deputy Minister, if he's here, to make his remarks, followed by the Commissioner and his team to make the presentation, be precise. We've received the presentation, we've read it, take out the salient issues out of it. Do that presentation of healthcare services. I also want you to present both, make both input at the same time, so that when members engage, I'm able to give them time to speak to both issues. Honorable Olomisa.
Good morning. Good morning, Chairperson. I'm sorry, I was struggling to get in.
Okay.
And I didn't hear the first part of your remarks.
Okay, I was just welcoming everybody. We're starting exactly at 9:30, and I'm asking that you lead your team with your remarks, followed by the Commissioner and his team to present the healthcare services in correctional centers. At the same time as you make your remark, I want you also to touch on both items, both the healthcare services and the KZN suspension, as well as the Commissioner, so that we will have the presentation tabled down and then we engage on both of those. Now I invite you, Honorable Deputy Minister, to speak to us. To listen up.
Good morning, Chairperson. Good morning, honorable members, members of the officials from the Department of Correctional Services. Thank you once again, Chairperson, for inviting us to come and account to you on particular aspects of the work that we do. As you have indicated, we've been requested to come and talk about healthcare services, in particular with reference also to the state patients. I'm not going to say much, Chairperson, to save on time, but to allow the department to present the presentation. But I do want to highlight the fact that we have a problem where we are required by law and practice to accommodate people who are not supposed to be in our centers, people who are mentally ill, having been declared so by the mental institutions after these people having been referred to the mental institutions by the courts, people who have been charged with committing serious crimes, only to be found that there's doubt as to their capability or capacity to follow the proceedings. And as a result, they are taken for observation. Once they are declared to be unfit or unable to be part of the criminal proceedings, then they are declared to be state patients because they can no longer be prosecuted. And the anomaly is that instead of them being directed straight to mental institutions by the courts, they are sent to our facilities. on the understanding that after a set period of time, they will be taken over to the mental institutions which are under the Department of Health. I think the reason, Chairperson, in the first place, they are in our premises is because initially, before they are declared state patients, as remand detainees, they are kept in our facilities so that they are available when they are required by the courts. Now that they are no longer required by the courts, they have not been convicted or sentenced, there's no business for them to be in our centers. So I came to understand that, in fact, beyond the requirement by the Criminal Procedure Act that they must be remanded with us pending trial, there's a memorandum of understanding involving the Department of Justice, our department, the Department of Police, and the Department of Health that calls upon us to keep these people for a period of time. But what happens is that after the expiry of that period, they still remain in our facilities, a number of them, because the argument by the Department of Health is that they do not have enough bed spaces or any space at all to accommodate these people. And we're saying, therefore, that is not acceptable. That even that memorandum needs to be reconsidered, because it's fine for them to be kept with us by us when they have not yet been declared state patients, when there's still a possibility they might be taken to court and attend trial to the full extent of it. So I'm suggesting to the department that they reconvene consultations with our colleagues in the other departments so that we don't find ourselves carrying out a responsibility that is not ours, that is not even, importantly, budgeted for. There's no money given to us, besides the fact that we don't have the capacity to do the work that is required around these people. On the matter of Mr. Nxele, Chairperson, honorable members, we could easily take the cop-out route of saying the matter is sub judice because it is before the courts or the arbitrators. But we do need to indicate to the committee that as the ministry, we are concerned, and I imagine the department also, that this matter has been dragging for so long. Obviously, looking at the various decisions of the courts, Labour Court in particular, that have been taken regarding applications that have been brought either by ourselves or by Mr. Nxele himself, challenging certain decisions, in particular, the matter of suspension. Well, these are the rights that people whose rights are affected are likely to in the courts. So essentially, because of that and any other considerations that the National Commissioner may share with the committee if that is necessary, he has had to be suspended, but on a number of technicalities, it has been found that the suspension period has expired without the department either seeking extension on time or with the department seeking an extension of the suspension after the fact. You find that at some stages, the court ruled that Mr. Nxele must be at work. And then during that period, before the decision has been overturned, he remains in court. Then later on, the department finds a court order in his favor, ordering that Mr. Nxele must not set his foot in our premises. And then a low merry-go-round that has been taking place. But it seems as if now we are on the brink of being ready to proceed with the actual trial, with the merits to be considered. Certain number of days, I think in June, have been set aside by the SSBC to look into this matter. And it is our hope that it is going to be now finalized, unless something else crops up that results from an action on the part maybe of Mr. Nxele seeking an interdict of one sort or the other. But the point of the department, of the ministry, has been that the rule of law must apply at all times. If the court says Mr. Ncele must go to work, he must be allowed to go to work. If the court says no, Mr. Ncele must not go to work, he must not go to work. So that is what has been happening. Hence this, what I call merry-go-round has been taking place. Otherwise, we are putting as much pressure as we can as the ministry to ensure what is necessary. What needs to be done is done. Now, with those few remarks, Chairperson, if you allow me, I'll ask the National Commissioner and his team to make the presentation. Thank you.
Thank you, Dilizindaba. Commissioner and your team.
Good morning, Honorable Chairperson and Honorable Members, Honorable Deputy Minister. Thank you for giving us this opportunity to present to yourselves. I have the first team that will present, and then they'll just switch and get the next team to present. The team that will present on the matter of the state patients is CDC Tobachali, who's the CDC for Incarceration and Corrections. I will hand over to the CDC to start, Chairperson. Thank you very much.
Thank you, Honorable Chairperson, honorable members of the committee. Let me also acknowledge the presence of the Deputy Minister, the National Commissioner, and colleagues. The presentation is on healthcare services in correctional centers, including services and treatment of state patients. It is arranged in two parts. The first part deals with the micro subject of services and treatment of state patients. The second aspect of the presentation deals with healthcare services in correctional centers. Slide 5 to 9 of the first part of the presentation sketches the background with regards to the service delivery environment that the Department of Correctional Services has to discharge the responsibility with regards to mental health patients. The Department of Correctional Services admits arrested individuals into correctional facilities as remanded by the court, and included in this category of inmates are those that are mental health care users. But at that stage, they would not have been confirmed by healthcare professionals in psychiatry. Assessments are made and diagnosis is made, and that is confirmed. Also, and in addition to that, due to court proceedings, a court order is issued in terms of Section 77 of the Criminal Procedure Act of 1977, as amended in 2017, that some of these inmates, remand detainees, are then declared as state patients, and they are then admitted into correctional facilities subject to provisions of Section 6 of subsection 42 of the Mental Health Care Act of 2002 that dictates that state patients be transferred from a correctional facility to a designated mental health care facility of the Department of Health within 14 days of the release of the court order. And this is released to the head of correctional center. So upon receipt of the court order, the head of the correctional center is enjoined to then inform the head of National Department of Health. In this instance, it would be our counterpart in the areas and in the regions of the fact that we have admitted a state patient with, of course, a cost, but they then need to be transferred to a healthcare institution that is declared by the Department of Health within 14 days. In line with the amendment of the Criminal Procedure Act, we then keep this state patients in our custody, in our care, beyond the 14 days, whilst we wait for the Department of Health to confirm the availability of bed space. Now, in administering this process, the Justice, Crime Prevention and Safety Cluster accounting officers, together with the accounting officer of the Department of Health, signed a protocol that is then meant to ensure that there is integration, to ensure that different departments and government agencies understand and they discharge their responsibilities jointly in an effective and efficient manner in ensuring that the state patients are then transferred to designated healthcare institutions. Now, also in terms of the background, we are also indicating that the number of declared state patients in the country continues to increase. And this is also due to the fact that mental health care users globally also continue to increase. But this situation is exacerbated by the global pandemic of COVID-19 and other effects of communicable diseases, especially HIV and AIDS. We also indicate that as of the 10th of May 2021, there were 123 state patients in DCS facilities, Free State having the number of 33 as the highest, Eastern Cape 31, Mpumalanga 24. And we are just opposing that with the improvements that we have registered in terms of statistics that we captured as at July 2020, as the number of state patients in DCS facilities was 198, Eastern Cape having 91, followed by Free State 37, and KwaZulu-Natal 24. The problem statement that we are presenting to the portfolio committee today is that there is a structural problem in the service delivery value chain with regards to healthcare services, in the sense that there is an inadequate number of designated Department of Health mental health institutions as required by the Mental Health Care Act. Also, there is non-availability of beds designated in the designated mental health care institutions due to the increase in demand, as one has already pointed out. Now, this in itself provides an infrastructure problem to the Department of Correctional Services, as we are enjoined by the Criminal Procedure Act as amended to keep the state patients in our care beyond the 14 days. And this has an impact on our resource allocation and also the utilization of the resources. I must also indicate that we work directly with the Department of Health on a daily basis, treating cases of state patients on a case-by-case basis. The Department of Health also provides to the Department of Correctional Services a psychiatrist that works directly with our officials at center level to ensure that we provide the necessary care to state patients. Slide 10 maps out the services that we render and the treatment to state patients as they are awaiting transfer. And we are basically sketching out the value chain, starting from orientation assessment as compared to what is prescribed by the Mental Health Care Act. On slide 13, what we are depicting is the number of mental health care users that are in our care. This would be mental health care users that would have been sentenced because they would have been fit to stand trial and they were not declared as state patients. We offer the same services that one has outlined in the previous slide. Slide 14 and 15 outlines the challenges that we experience in the process of transferring state patients. The first one is that in terms of the law, state patients are supposed to be transported by South African Police Services. In most instances, our colleagues from SAPS do not have the expertise to care for mental health care users over long distances, so we have to provide that support. But also there is that reluctance from SAPS to transport these patients out of DCS facilities. The Gauteng province limited capacity affects our correctional centers in Mpumalanga because the mental health care institutions that have been designated are in Gauteng. So Gauteng takes care of also of Mpumalanga. We are also indicating the challenge that one did sketch out in the background, that despite the fact that we transfer, the demand continues to grow, whilst the infrastructure that we have does not necessarily grow or develop further. We also map out the impact of COVID-19 and how the infrastructure provision in Department of Health had to now address COVID-19 in terms of quarantine and isolation sites, and that further reduced the capacity to admit state patients. So there is increased pressure on the existing resources, and also the focus then is also on ensuring that the pandemic is managed. There are mitigation interventions that we are implementing in line with the protocol that has been signed by accounting officers, as one has presented in the previous slides. And those are actually bearing the necessary results, in the sense that the numbers that one has been able to present come through in terms of the transfers that we are able to facilitate. As DCS, we avail audiovisual facility to psychiatrists from the Department of Health, and this ensures that state patients within our care continue to receive the required care, but also the assessment and the diagnosis happens faster. We have devised tools to ensure comprehensive and consistent management of state patients, and this we have done jointly with the Department of Health, and we administer those tools jointly. We also avail COVID-19 PCR results of less than 72 hours prior to the transfer, because this is also a condition, and the Department of Health then is able to admit state patients more quicker. In terms of the proposed way forward on this aspect of the presentation, we are making a contribution with regards to the process to review the criminal justice system, and the contribution is aimed at ensuring that the issue of the availability of bed space as a condition for transfer of state patients in the Criminal Procedure Act is that aspect of the Act is expanded so that upon court order issue, state patients can be taken directly to mental health care facilities. But also in the short term, we are also facilitating with the accounting officers of the Criminal Justice Department and Department of Health for the review of the protocol, to also look at the issue of the capacity of the Department of Correctional Services to continue housing state patients beyond the 14 days, but also to look at the capacity of the Department of Health in terms of increasing the available bed space, but also, if possible, designation of more facilities as healthcare institutions under the Department of Health. I will then move to the second part of the presentation, Honorable Chairperson and Honorable Members, which deals with macro aspects of the healthcare services in correctional services. Slides 19, 20, and 21 locates the healthcare services within the incarceration and corrections branch as part of a value chain for a provision of care services, rehabilitation and correction services to sentenced offenders and also remanded inmates. And we outlined the objectives of the branch, but also one would then quickly go to slide 21 that outlines
salient point. Let's go to the salient points. Go to the key salient points.
Thank you, Honorable Chairperson. I will then not necessarily then present the core functions. They are stated there. I will move to slide 22, slide 23, and slide 22 and slide 23. Both slides are basically presenting the capacity of correctional services at center level in terms of human resource with regards to healthcare services. We are disaggregating the capacity that is available in terms of the professions, from medical practitioners to custodial. On slide 23, we are showing the capacity we have in terms of regions. Then we move to slide 24. Here we are just opposing our capacity with the availability of a member, looking at the ratio between a member and the number of inmates that we have, and we're just opposing that with the norms in terms of the World Health Organization. And the numbers show there that we are slightly below, and it shows that there is a pressure in terms of the human resources that we have as DCS at the central level. The next slide, slide 25, is basically an outline of the footprint of the infrastructure that we have in the correctional centers on healthcare provision. And we're looking at clinics and inpatient facilities, pharmacies, and food service units, because healthcare services is also responsible for nutritional services. Slide 26 depicts the budget that is at our disposal in terms of rendering the service. But what we are also indicating there, that in as much as the budget increases, it increases at a decreasing rate. Slide 27 then maps out the challenges from the structure of the department needing to be more accommodative of the services with regard to healthcare, to the number of posts that are limited in terms of the healthcare professionals. But we will also, in the next slide, which is slide number 28, we are mapping out the mitigations that we are putting in place as the department on a short-term basis in terms of provision of additional capacity, and also on a long-term basis in terms of looking at the process to review the organizational structure and provision of capacity on healthcare services. There are other areas that we are mapping out in terms of challenges on facilities, and we are also indicating what are the mitigation interventions that we are putting in place, that we are implementing in terms of the annual performance plan of the Department of Correctional Services. The same we are doing with finance and supply chain management and government information technology services. And also, Honorable Chairperson and Honorable Members, we are then lastly presenting pointers in terms of service delivery improvement measures that we are continually implementing, making it a point that at the structural governance level, but also in terms of the functioning and operation, the department is on a daily basis able to discharge the responsibility in terms of our mandate with regard to healthcare services. And the last slide, Honorable Chairperson and Honorable Members, simply concludes indicating that we have these challenges, but as a department, we are addressing them in terms of the pointers that one has given with regard to service delivery measures that we continue to implement. Thank you, Honorable Chairperson and Honorable Members. Thank you, Deputy Minister, National Commissioner, and colleagues. The presentation ends there.
Thank you, Chairperson. I'll now get Ms. Kikana and Mr. Killian to do the second presentation. As per your direction, thank you, Chair. Mr. do you have the presentation? Mr. Killian.
Thank you. Good morning, Honorable Chairperson, Honorable Members, Honorable Deputy Minister, Commissioner. I'm going to start by firstly saying, before I continue with the presentation, just to mention that there is currently litigation in the Labour Court, as the Deputy Minister mentioned, as well as the arbitration, where the merits of the matter will be heard. So I'm not going to go too much into the merits or the detail of the matter, in order to protect those processes. If I can go to the first slide. just a background. I'm not going to go too much into the issues of when Mr. Nele is appointed. Safe to say, Mr. Nele has been on suspension since 2 December 2019. Although in between he returned to work briefly on some instances, and this is when there was court orders or other orders that says he must return to work. The suspension of Mr. Nele is necessary to ensure the safety and well-being of witnesses, and I think this is something that's very important that we need to note. He's charged for various acts of misconduct in relation to the disciplinary referrals from the SIU in relation to Proclamation 10 of 2018, and the estimated value of those contracts, and I'm saying estimated because obviously we will have to count the actual payments that was made, is 92 million rand. The disciplinary matter, which is now under this arbitration of the GPSSBC, the council, is set down for 22 to 25 June 2021. Next slide. If I can go to the current disciplinary matter, just to outline a little bit more, the department receives various disciplinary referrals, and on 11 of September, the 1st of October, 11 of October, 21st of February, all of them referring to tenders or bids that was issued in KZN and which relate to the charges that we are charging Mr. Nele with. The last referral also goes into more detail into issues of lifestyle, non-disclosure of assets and those kind of things, which I do not want to go into detail now. I must say that Mr. Nele was given the opportunities on all these allegations to respond, but he chose at the time not to respond on any of the allegations. Instead, he brought various applications in court to challenge the suspension. The next slide. Mr. Nele was first served with a notification for disciplinary hearing in February 2020 with a provisional charge sheet. At that stage, we were still receiving some referrals from the SIU, so we made a provisional charge sheet. The disciplinary hearing continued on 18 February, but was postponed to 24 and 25 March. In that period, Mr. Nele brought an application in the Durban Labour Court to set aside his suspension. 10 March 2020, there was a judgment in his favor, but that was not operationalized because there was an appeal, and when the appeal was refused, we petitioned the Labour Appeal Court, which was then granted. On the 6th of May, the Labour Court also ordered that the judgment of 10 March is not operationalized. The disciplinary hearing was then set down for 18 to 25 May, but due to the COVID pandemic and the regulations issued at that stage, it was postponed by the chairperson, and the chairperson at the time then ruled that the suspension of Mr. Nele is extended. On 5 June, Mr. Nele then, the 2020, brought another motion application in the Labour Court to set aside the decision of the chairperson and to once again operationalize the court judgment of 11 March. Judgment was then in favor of Mr. Nele to set aside the ruling of the chairperson to extend the suspension, but found that the judgment of 6 May that refused to operationalize the judgment of 10 March means that Mr. Nele could not return to work until the Labour Appeal Court ruled on the petition to appeal the 10 March judgment. That was the situation then. The disciplinary hearing was then again set down for 6 to 10 July, and that was the only time that the chairperson was available. They also directed that parties must raise all their preliminary points before 24 June. During this period, the legal representative of Mr. Nele indicated he does not have a mandate anymore from Mr. Nele, and even if he does have a mandate, he will not be available on 6 to 10 July 2020. The hearing then continued as scheduled from 6 to 10 July in Peter Marisburg, KZN, and Mr. Nele attended without his legal representative. During the hearing that commenced on 6 July, Mr. Nele immediately brought an application to have the proceedings stopped so that it can be converted in terms of Section 188.11 of the Labour Relations Act into 188A proceedings. That means it refers to the Protected Disclosure Act. Then on 9 July, the chairperson following case law ruled that the proceedings must be converted to Section 188A of the LRA proceedings. That means the whole process then moved to the GPSSBC, and it is heard before a panelist of the GPSSBC. And that matter was allocated number 724 of 2020. And this is the matter that's also set down for 22 to 25 June to be heard on the merits. The pre-dismissal arbitration was set down, as I said, on 21 to 22 September, but postponed to 26 to 30 October on the request of Mr. Nele because his legal representative was not available. During this period, because the previous disciplinary process was stopped by the chairperson, and there's now a new process before the GPSSBC, and advice from our counsel who's initiating the matter, the National Commissioner served Mr. Nele with a convocation letter on 17 July. Mr. Nele was suspended. An application to extend the suspension of Mr. Nele was then presented to the arbitrator under GPBC 724, but it was dismissed due to lack of jurisdiction by the arbitrator. However, the arbitrator mentioned in his award or his ruling that in terms of section 188.12 of the LRA, it's not wrong if a person is suspended during arbitration proceedings. The National Commissioner then informed Mr. Nele that he remains on suspension until the finalization of the arbitration. The pre-dismissal arbitration continued on 26 November, but Mr. Nele at that time then brought an application for further particulars or discovery, as we refer to it. After various exchanges in terms of discovery of documents, the GPSSBC on 16 February indicated that the pre-arbitration is set down for 23 and 24 March to finalize all our issues in relation to discovery of documents. On the 24th of March, the panelists then ruled that the discovery of documents is now finalized and the matter is set down for hearing on 22 and 25 June. At this stage, we need to indicate that the department is completely ready to continue with the merits of the matter against Mr. Nele. If I can briefly turn to the suspension issue, which was a separate application that Mr. Nele brought in front of the GPBC in terms of the LRA as an unfair labor practice. In relation to the suspension of 17 July, the matter was heard on several days during December, March, and April 2021. And on 26 April this year, the arbitrator issued an award in favor of Mr. Nele, and he returned to work on the 3rd of May. However, the department, who allowed Mr. Nele to return to work because there's an award, filed to review the award and simultaneously asked the court to stay the enforcement of the award. And on 5 May, the Labour Court in Johannesburg granted an order in favor of DCS that Mr. Nele is interdicted and refrained from reporting pending the review of the award. Mr. Nele did not accept that, and he then brought an urgent application in the Durban Labour Court to rescind the order of 5 May, but on 13 May, the Labour Court in Durban dismissed that application. Mr. Nele is therefore currently on suspension and pending the finalization of his pre-dismissal arbitration before a panelist of the GPSSBC. I think that ends the presentation. I don't know about it.
Thank you, Chairman.
Thank you. Is that it, Commissioner? Thank you for the presentations. Honorable members, I now invite your comments, questions, clarities, and interventions. I see the hand of Honorable James South. Can I see any other? Honorable Yako, Honorable Velma Meevout, in that order. Honorable Self.
Thank you very much, Chairperson. If I can start with the second presentation first.
Sure. It's you conducting the choir there. Go ahead.
Thank you. The first issue of clarity is on slide 6. I assume in the second last bullet, the 22nd and 25th of June 2020 refers to 2021, just by way of clarity.
Yeah.
But what we see here, I think, is classic delaying tactics. And I'm not sure whether the department has any way of overcoming that, but I also am disturbed by the fact that the department has not succeeded in some of these applications. And I wonder whether the department is adequately represented or advised. So, for example, when Mr. Ngele succeeds in challenging the suspension, I'm worried that we perhaps are not fully on top of the case. But this matter has dragged on and dragged on and dragged on, and I really do hope that on the 22nd and 25th of June, 22nd to the 25th of June, there'll be some clarity about it. Moving to the first presentation, the detention of state prisoners' patients is a classic unfunded mandate. And I'm fully support the attempts by the department to renegotiate the memorandum of understanding, because it's outrageous, actually, that simply because there's no bed space in mental health facilities, they can be dumped into prisons, where there was over 4,000, if I saw correctly. And that must affect the bed availability in prisons as well. Prisons are also overcrowded. And that brings me to the concern that I have that state prisons patients are typically vulnerable people, and they may be subject to abuse. And what guarantees or what measures are taken in the centres to make sure that vulnerable people are properly separated and that mental health patients at least have their own beds and decent facilities. Thank you, Chairperson.
Thank you, Honourable South. A quick response, Commissioner.
Thank you, Chairperson. I'll ask the CDC incarceration to first respond, and then Mr. Killian. Thank you.
Thank you, Honourable Chairperson and honourable members. The first statement from Honourable Self was a statement in support of the department's way forward in terms of how do we then treat this matter in a more sustainable manner. We appreciate their support and will avail ourselves to the committee to continue to brief the committee in terms of the progress we're making with regards to the amendment of the protocol as signed by accounting officers. The second part is on the measures that we are putting in place. In terms of the Correctional Services Act, what we then do is to provide separate accommodation for state patients and mental health care inmates. We make it a point that we provide security services that will ensure that they don't become a danger to themselves, but also a danger to other inmates. We are also aware of the fact that they are also exposed to other risks in our centers. Hence, we make it a point that we provide for their care separately from other inmates, from an infrastructure provision point of view, and also care services. Thank you, Honourable Chairperson and honourable members.
Thank you, Honourable Chairperson. Firstly, to comment on the comments of Honourable Member Self, that there's delaying tactics. Yes, that's true. And as long as it's done within the ambit of the proceedings and the law, we will have to deal with that as long as it continues. But we do anticipate and prepare for those. On the second question, is it not that the department was not adequately represented during some of these court proceedings? We did have some challenges at one stage with being represented by different state attorneys. But with the assistance of our legal services, the Office of the State Attorney and the National Commissioner, we managed to centralize all the dealings of this litigation into one office, the State Attorney, who was really assisting us with one person, and I think we've managed to solve that issue. Thank you. Thank you, Commissioner.
Thank you. Honorable Nomambondo Miseyako.
And Ghost Chairperson, I'm going to put my video off because I don't have such a good network this side. I think I will go in the direction of Honorable Self, starting from the last presentation to the first one, along the same lines. I just want to ask the department, basically, who else has been fingered by the SIU besides Mr. Ngale? And with all this up and down that's happening, how much is it costing the department to actually proceed with this case? And in the meantime, who is actually standing in for him? That is my question. Secondly, on the part of the mental health and prisoners, I know the department has answered now, saying that it's looking into creating some sort of space for them to have special care. But I worry that in this country, I don't think we take mental health so seriously. And it's quite a pandemic on its own. I just want to understand from the department's point of view, how much are they relying on the Department of Health to assist, but not lean on them? What are they doing, and what are the timelines that they're giving us on what plans they have with regards to mental health patients, having special care that is specified to mental health? Thank you, Chair.
Nkosi, thank you. Quick response, Commissioner, to Honorable Yako's comments and questions.
Thank you, Honorable Chairperson and Honorable Member. If I had the question correctly, is who else is charged with Mr. Nele? At this stage, Mr. Nele is alone in disciplinary hearing, and this is where we go to the merits of the case. So I would not like to say much about that. On the second issue of who is standing in for Mr. Nele, that's Mr. Ntombeli, a Deputy Commissioner who's currently acting in KZN as the Regional Commissioner. Thank you, Chair.
And the third aspect is about how much this has cost, the value.
We'll come back to that just now, Chairperson.
Before the other one responds, let me just beef up that question of so that when you think about it, we get the response before we close. It's going to be important that you quantify how much in legal fees has been paid so far, just on this case. How much in legal fees has been paid? In other words, we were looking at the value, how much of the taxpayers' money has been built here. But also, secondly, between the DCS and Mr. Ngale, because Mr. Ngale is still in the employ, is he also utilizing state funds in his defense around this? So, because you would need to just quickly check that, you would be able to know in answering Ms. Yako's question, and we'll come back to our response on that. But Commissioner, the other person can attend to the other questions so far.
Thank you, Honorable Chairperson. We worked together with the Department of Health. That's the extent at which we then depend on the availability of psychiatrists and health professionals that the Department of Health provides to state patients as they are required to provide that service in terms of legislation. We also have our own psychiatrists and healthcare professionals in the department. At our centers, we provide services to mental health care patients in our care, utilizing the same healthcare professionals. We work together with the Department of Health in the context of also managing other health issues that we manage on a daily basis as DCS. With regard to the timelines in terms of the review of the protocol, we are looking at ensuring that the processes would have started and we will have a draft in place in terms of the discussions between the accounting officers within 30 days. And as one has indicated, we're looking at exactly addressing the challenge of the availability of bed space, but also designated mental health care institutions, and augmenting the capacity of the Department of Correctional Services to discharge their responsibilities with regard to state patients. Thank you, Honorable Chairperson.
Thank you. Thank you. We proceed. Honorable Velma Nieuwoud.
Thank you very much, Chair. And good morning to everyone on the platform, and good morning to the team from DCS. Thank you for the presentation. Just a few questions. Chairperson, you may rule me out of order for my first question. I'm not sure if I'm allowed to ask this particular question in relation to the second presentation. What I want to ask is that the SIU, in all the cases or referrals proclamated, are they all finalized? Have all the proclamations or all the referrals been finalized? And then in relation to these referrals, have there been any criminal charges laid, or is that one of the questions that you can't answer? So I'm not sure, Chair, if they can answer that or not. Then to the first presentation, I saw somewhere that the number of doctors, medical doctors, and from that number, how many are psychiatrists employed by the Department of Correctional Services. I understand that you said the Department of Health send their psychiatrist, but from DCS, on the DCS payroll, how many psychiatrists do you have? I would also like to know who administers medication daily. Is it the health practitioners from correctional services, or is it health practitioners from Department of Health who have to come daily to administer the medication? And in terms of the services you provide, is it just administering medication to the mental health users, or do you have other mental health care that you provide? Yes, if you could answer that. And then you had said that in remand, up until the court decides that the person is not fit to stand trial. So in that time, the person waits in remand detention. During that period, even if the person, is already, already on mental health care, do they still get their medication administered while they're on remand, or do they not? And then when they are once declared not fit to stand trial, the judge makes that decision and then they go back to correctional services. What I would like to know that on average, if it goes over the 14 days where they are supposed to be where they are limited to be in the center, but it goes over 14 days. What's the average amount of days that you have to keep them for? The question is that, if the judge sentences a person to like 5 years in jail, but if somebody is declared unfit to stand trial, how long then are they supposed to stay in correctional services? Because if they stay for longer than 14 days, and it's well past the 14 days, so how long is a person who becomes a state patient, how long on average are they detained for? In your budget, you then showed that it wasn't clear in your budget that is it part of it covered by the Department of Health, or is that entirely the Department of Correctional Services budget? And yes, I just wanted to make sure that I have all my questions, because I know that Chair will not give me a second bite. So yes, those are all my questions. Thank you so much.
A serious accusation. Anyway, thank you, Velma. Commissioner and your team, please respond to Honorable Velma.
Thank you, Honorable Chairperson and the members. Just to come back to the issue of the legal costs, what we have at this stage is 1.9 million that has been spent. That includes all the various litigations, and there has been quite a number of them in this matter. I don't even remember the number of times that we've appeared in court for applications for suspension, etc. Going to the issue of the SIU.
Just repeat what you just said. Just repeat your earlier point.
Oh, the earlier point. I'm saying that the amount the department has spent in this matter on legal costs is estimated now at 1.9 million. And this is for various...
with all of this.
Sorry, person, we didn't hear you.
You're saying it's only 1.9 million so far?
Not only 1.9, it is 1.9 million.
Okay.
And that's for various court matters where there was litigation. Maybe it's important to note that the department has only brought one application, and this was the last one. All the other applications is where we were defending, opposing court applications. If I may continue, say, on the second issue of whether we've received all the SIU reports on proclamation. Now there are still some reports outstanding, especially on the last one of the PPEs. We've received disciplinary referrals, but there is some outstanding issues that are busy with. On the issue of whether there have been criminal charges, that is something that we will have to verify, because the SIU makes referrals to the NPA in terms of criminal charges that they want to refer to the NPA. So we will have to verify that with them. Thank you, Chair.
Thank you, Honorable Chairperson. The other question. The budget as presented in the slide is a budget that refers to Department of Correctional Services only. Yes, we do administer medication to state patients and mental health care inmates that are under our care, but there is a slide, Honorable Chairperson, where we are also indicating that we offer diagnosis, assessment, follow-up care services, and we do that also working with the Department of Health, as one has indicated that we provide the necessary infrastructure for Department of Health psychiatrists to come into our center and offer the services that are required to each and every patient that we will be taking care of. The 14 days in terms of the act, as I indicated, we work closely with the Department of Health to make sure that we reduce the delays in terms of the time that state patients spend in DCS beyond the 14 days. On average, in terms of the work that we have done so far, these state patients stay in our care between 1 and 6 months in terms of the duration. There will be instances where there are those that have their conditions are severe that would stay longer because they would then need special care from the Department of Health and would then be awaiting for confirmation of bed space from the Department of Health. Thank you, Honorable Chairperson.
Okay. Thank you. Honorable members, any quick follow-ups from your side before I come in? Any member with a follow-up, clarity or question? If none, so that I
Hi, Chair.
Yes, Honorable Yago.
Yeah, I think I'm really quite disturbed by the amounts that the department is talking about with regards to this case, and I think the presenter from the department really needs to be brutally honest with us as to how many other people are actually involved, and not just have this one sacrificial person that the department is headlining as if it's doing something to combat corruption. And we're spending so much money, but how many others are involved in this investigation? It cannot only be Mr. Ngale who was acting alone, and we know that that's not a fact. But I think we really need to be open and honest about what the department presents to the committee, so that we can then make informed sort of deliberations on the matter, if we are able to.
Okay, thank you. Honorable Velma.
Thank you, Chairperson. I am not clear. I wanted to know, are there other mental health services provided other than medication? So I mean, one-on-one consultations, those kind of things. I didn't get the clear response. And then my second one, I'm a little bit concerned. Yes, you said that you keep the person on average 1 to 6 months. Now, the one thing that I wanted to know, before that person is released, say after 6 months or whenever they get transferred, whether they go to a mental health facility or go home, do you engage with the family? I'm concerned here because if the inmate was there, for example, this is just an example, for an alleged murder, and they were declared unfit to stand trial, then they kept in the correctional services facilities, but they can't stand trial for a murder case. So it will be a threat to let him go out into the community or his family because of the severeness of the illness. Now, if he's released from correctional services, even though he didn't stand trial, he's released. Where does he get released? Is he only released to a mental health institute, or does he go back home to the community? Thanks, Chair.
Thank you. Commissioner, please respond to both honorable members, Yako and Valma.
Can you get Mr. Killian and then the CDC Chair?
Thank you. Thank you, Honorable Chairperson and Honorable Member Yako. On the issue of whether other people are involved, I want to, and I've said this in the beginning, Honorable Chairperson, this goes to the merits of the case that we have in front of a panelist of the GPSSBC. It's part of the case that the department is going to present as to what transpired there, and I'm really not at liberty now to talk about who's involved and who's not involved. Otherwise, that will compromise the whole case of the department. So I would like to leave it there and urge the committee to indulge us on that. As much as I hear that we need to be open and honest, we need to also respect that there's an internal process going on. And let me just leave that there. Thanks, Chairperson.
Thank you, Honorable Chairperson. On the issue of the release of state patients, we released state patients to the care of the Department of Health to designated healthcare institutions as outlined in the presentation. With regards to the services that are rendered to mental health care patients, but also state patients, we render services in line with the levels of care that exist in DCS. Our nurses administer the medication that would have been prescribed by our medical doctors. In cases where there is a need for sessions for counseling, we also have our psychologists that would come in and have one-on-one sessions with the state patients, where in terms of the diagnosis and assessment, we also provide, in line with it, also provide sessions with the psychiatrists. And this is a team that is then available to our users in terms of mental health care, but also state patients when they are in the care of DCS. We also, together with the Department of Health, have consistent interactions with family members, but as I've indicated, we release them to the care of the Department of Health in the designated healthcare institutions in line with the legislation. Thank you, Honorable Chairperson and Honorable Members.
Okay, Honorable Jele.
Chairperson, I'm sorry, I'll be short. I'm coughing, so I'm avoiding to talk. I think, Chairperson, I would want to follow up on what Honorable Yaku said. I don't think that it's acceptable that we are saying, the department is saying to us, they will never entertain the issue of who else is involved. If they don't have that information now, it's fine. But we want that information. It must come, Chairperson. There is no way that one person can be the one who is being sacrificed in this matter. Please, can we get more information on this? I really don't. Thank you, Chair.
Thank you, Honorable Jele. It's not a question for response. I think it's a request for more information. So I think the department will have to deal with that. Commissioner, your final input. I've not heard you today. I know you've been a good conductor. Then after you, I'm going to the Deputy Minister.
Thank you, Chairperson and honorable members. Chair, again, I want to thank yourself and the honorable members for the engagement. I think it always enriches us and challenges us to reflect on what we do and how we do it. So on the issue of state patients, we are going to engage on the review of the protocol and we'll report back to the committee within the next 2 months on that matter. I think with regard to Mr. Nlele, I will provide the full scope of the cost here, because when I calculate the cost in terms of to department and not legal costs, there's a further cost of about 1.58 million that we've expended based on his suspension. But I think what's important to state, Chair, is the fact that the reason we have persisted, or I've persisted with the issue of suspension, is that on one of the occasions, that the RC returned to his office. He returned with a few parolees as bodyguards. And I want to state up front that witnesses in this matter are female officials who had come and registered a complaint with me as an accounting officer, and I felt it incumbent to protect witnesses that is prepared to deal with issues where there may have been malfeasance. I also think, Chair, that when this matter is concluded on the substantive issues, I want to build a case study on that, because I think there's a number of issues that have happened over this period that requires the attention of this committee. Because I think the case study out of this must be presented, because I think it can help the government at large. So I'm proposing that once this matter has been resolved, that the department comes back and look at this, evaluate this matter, its protraction, its cost, and all of that, and then identify where we think there have been challenges. I think there's a big investigation required on this, Chair. With that, I want to thank you once more. Thank you, Chairperson.
Thank you, Honorable DM.
Thank you, Chairperson, once again, honorable members. Regarding it is our intention at all times to be frank and open and candid and honest as far as practicable when we come to this portfolio committee. When I opened my remarks, I did refer sort of glibly to the principle of what is called sub judice, where matters that are before court are not supposed to be delved into, especially when they border on the merits of the matter. I think that is partly the reason the department is unable to give a clear answer to the question as to who else or how many other people are charged. The logical question being, looking at the nature of the case facing Mele, it's not possible that only one individual could have been involved in the commission of the offense. So therefore, the suspicion or understanding is that there should be other people. But now the case is yet to be tried. It has not yet been heard. And as such, the revealing of some information might jeopardize the case of the state or the department. I think that is the reason why. But we shall, as a department and the ministry, confer on this and see how we can take the portfolio committee into our confidence, which would mean the entire public in South Africa would have to be taking them into our confidence when we disclose certain information. So we have to be sensitive to some of the rules that are applicable in the hearing or trial of matters such as this one, where some information cannot be publicly disclosed. But we shall find a way of taking you into our confidence by indicating to you how exactly the entire matter is progressing without jeopardizing the interest of the case itself. Then we are happy, Chairperson, that our observation, particularly as the ministry, which has subsequently been shared by the department, of the irrationality of having patients who are not facing criminal trials in our premises when they should be taken to where they belong. And indeed, the National Commissioner has already indicated that within a short space of time, we shall report to the portfolio committee as to what we are doing regarding the review of the protocol that forces us at this moment to carry these people when they are not really our responsibility for the reasons that have been stated also. We don't have the full capacity to look after them. It's not our core responsibility anyway. Even if we work closely with the Department of Health, these are people who are supposed to be in their premises. And otherwise, Chairperson, once again, we want to thank you for the probing questions which contain in themselves advices as to how we should carry out some of these sometimes difficult responsibilities. Thank you, Chairperson.
Thank you, Honorable DM. Now, let's just as I summarize, maybe before I do that, because again, I'm going to do what I did last week. I will check with the committee, because last week we concluded and asking you for further concrete information on a number of issues. And I'm hoping that that is already on its way if it has not reached us, because the kind of information and feedback we need, it's not information that you must go and generate. It's already there with you. So when you get out of this meeting, it should be something you prioritize so that we don't pack up things, because every time we meet, there's likely to be more things that will require from you. I remember last week I asked you as you left very detailed information that we needed. And I'm hoping that if you're not done with that yet, you're almost close to finishing that so that the committee secretary can get that. And for today, I think as we sum up this discussion, we are going to require you, Commissioner, and your team, and the DM will be guiding you on this. You would need to indicate to us the timeline on this process of renewal of the Memorandum of Understanding. We want to be very concrete about that. In fact, let me assist you that by the 4th of June, we will rise and we'll go and do the other work across all parties that we're going to do in 2021. And that when we come back in August, we're going to require you to come to us and present not just the progress. You should have finished by then, reviewing together with all other stakeholders this Memorandum of Understanding that is critical to be reviewed, because it doesn't make sense as things are. So that's more than 3 months that you are given, if that's a timeline, up to 4 months or whatever that we're giving you. So you can come back and tell us how far you have traveled. And based on that, once you do that proper work, it will allow us as this committee to engage with the other relevant and affected committees. So you'd have done the work at an administrative level, operational level, at a technical level. It will allow us to then be in a position to convene the other affected committees so that there's a collective approach with the others that you have listed here. All of that depends on how much work you're going to do from now until then, in terms of Deputy Minister and Commissioner, this process of this MOU that you need to begin to review. Members are supporting that. So that's the first point. The second point, maybe to broaden it, I've said this before in 2019, not only in this department, in all other departments, Department of Justice and others, that the internal litigation cost is a worrying phenomenon. And I'm broadening this beyond Nile. Because Nile is just one piece of this litigation cost, and because in certain instances it could be issues of disciplinary things and this and all of that, just beyond Nile. So this is not the first of those. So where sometimes you gather that there seems to be a cold war within, that's why I'm calling it internal. It's not litigation cost because there's an external pressure that you have to deal with. And I'm asking that you also come back, when we come back beyond August to present to us this item of the litigation cost within the department, where you'll be breaking it down, both what is internal in those litigation costs, values of that, reasons for those, what could have been done besides the litigation, as well as the external part of it. Because once you have that, we are going to have the entire picture. So I'm just broadening what was asked earlier in that regard. The third and the last one is on this issue of mental illness. As you do this work, I think you've given us a sense today of the state patients. I'm sitting here knowing that in terms of the wellness, I am very much interested in the wellness of the officials as well, not just the state patients. It will be important that you share that with us in terms of how they are affected by all of this and so on. So otherwise, with all of that, thank you very much to you, DM, Commissioner, and your team, members, and everybody in the meeting. The meeting is now adjourned. Thank you.
Thank you, Chairperson.
Thank you,
Chairperson. Chairperson. Wilma.
Wilma.
Sorry, Chair. It's not related to the meeting, but the minutes of the previous subcommittee meetings, can those be finalized because we need to adopt them, please, so that it doesn't pile up? Thanks, Chair.
That will be attended to. Thank you. Thank you, colleagues.